So introducing the speaker for this next session, Andrew Serwin, who actually, we work with Protiviti in a number of cases and engagements. Andrew is a partner of global privacy and data security at Morrison Foerster. And a few of the things here in his bio, some notable mentions. He's handled multiple privacy matters before the Federal Trade Commission, a few of which we've worked with on him, as I mentioned. Advising Fortune 500 clients on privacy matters, compliance, eCPA and wiretap issues, FTC requirements, as I mentioned. He's also been recognized by Chambers USA as one of the top privacy and data security attorneys nationwide. And I think this will be a pretty engaging talk where it's been very exciting, and there's more exciting days to come with the HIPAA Omnibus Rules. So there's some teeth behind these rules now. And I'll go ahead and let Andrew get started with the presentation. Thank you very much.
Thank you. And the first thing I will do, thank you, is introduce my co-panelist, Michael Cox. After I was asked to speak here, I did what I always do when I have a HIPAA seminar, is I asked Michael to come join me because Michael has a tremendous amount of operational experience in HIPAA as well as with the Federal Trade Commission, and has worked with a number of leading healthcare companies such as Pathway Genomics, also in the financial services space. So Michael and I are going to tag team this today, and Michael will come in and frankly lead us off with starting with where we've been. It's been a busy HIPAA year. I will talk about data breach a little bit later, and also some of the times where OCR comes knocking and wants to enforce, or the Federal Trade Commission comes in as well. So Michael, I will let you start it off.
Thank you, Andy. I'm going to spin off of something Adam just was talking about. There's a lot of attention paid to PII and PCI data. Most people probably know that PCI data is worth about $1.50, $3 in the black market. Does anybody know how much medical or health insurance information is worth in the black market? $40 to $60. Do you know why it's worth so much more? Take a crack at it?
You do a lot more with it.
Yeah. Absolutely right. So over the years, there's been a lot of fraud protections built in on the financial services side that aren't in place. And so, we tend to think about the impact on organizations when a breach is suffered, but it's worthwhile to really think about the impact on patients as well. Once your medical record potentially gets compromised, first of all, why would anybody want to steal health insurance information or medical information? Could be to get access to drugs, could be to get access to health care, or just to resell it. Once the medical record is compromised, if it happens to be your medical record, you don't know whether you're going to be treated properly the next time you make a visit. So it has very serious implications from a patient perspective that isn't often discussed. So I thought maybe we'd start with that one. Okay, so this is out of the Department of Health and Human Services news release about the ominous bill. Greatly enhances a patient's privacy protections, provides individuals new rights, and strengthens the ability to enforce the law. Unfortunately, the HIPAA security rule was largely left alone. It's 10 years old. There's lots of new technologies, threats, and risks that have come up in the last 10 years. If you're relying only on the HIPAA security rule, you're probably in trouble. That's not an adequate framework alone to protect your organization. Happy to take questions about that later. Where most of the changes are on the privacy side. The only way where they really touched on the security rule side was with regard to the BA. There are a number of changes. This is just a high-level review. Modified the standard. Fernando talked about that. It's no longer a harm standard. It's a 4-factor risk-based analysis that's required to demonstrate low compromise, and you better document that. It's extended Department of Health and Human Services Enforcement Authority over BAs. Before this, they were just contractually accountable to the covered entity. Now they're directly civilly and criminally liable. Expanded the definition of BAs. We'll talk more about that later. Modified the requirements of BA agreements. There is an example of some of the clauses that need to be in the new BA agreement on the Department of Health and Human Services website, but it's not complete. New obligations for BAs to enter into BAAs with their downstream subcontractors. Removal of limitations of liability for acts and omissions. We'll talk more about that. Changes to requirements for notices of privacy practices. I noticed how long this hospital's was when I came in the front door of the hospital. New limitations on the sale of PHI. New limitations and clarifications regarding disclosure for marketing purposes. We'll be talking about all of those, as well as relaxation of certain limitations for fundraising, and improving, actually, the authorization for use and disclosure of PHI used for research. Okay, most people know what the impacts are. And by the way, most people in the privacy business are lawyers. Most people in the security business are technically trained. I'm neither. I'm sort of a new breed of cat. I'm an enterprise risk management guy. So I think about things from a risk perspective, and you're going to hear that as we go have a conversation today. Of all of these impacts, what do you think is the most surprising to CEOs of compromised organizations? Anyone want to take a shot at it? I'm sorry, you don't have a mic, just yell out. No? The most surprising is the loss of productivity by the CEO and many of the C-levels in having to reestablish stakeholder confidence. One CEO said it took 1.5 years out of his regular CEO life. It's not just something that CPOs, Chief Privacy Officers, and Chief Security Officers have to handle. Now, when an organization comes to me, it's usually for one of these reasons. It might be because a business partner is now requiring them to be HIPAA compliant or even compliant to a higher standard. When I get in front of, I usually insist that I get in front of the responsible executive. I talk about these other ways that your program can come under scrutiny, and it usually opens some eyes. Complaints come into the FTC and Department of Health and Human Services every day, and those complaints are monitored, and oftentimes that can spark an investigation. KPMG was commissioned to do 150 audits. They did 15 at the end of 2011, which is the basis for the audit protocol, if you're aware of that. That's published on Department of Health and Human Services website. It's not been updated for the Omnibus Rule yet, though, unfortunately. I have updated it. A breach can bring you under scrutiny, and it really doesn't matter what the cause of the breach is. It does matter, but your whole program is going to be evaluated, not just what the cause of the breach was. Business partners, we already talked about that. Acquiring companies. You know, I learned this from Andy, who has some experience regarding this. There's this thing called successor liability. The acquiring company acquires the liabilities of the company they're acquiring. And if there happens to be a breach that hasn't revealed itself yet, because sometimes these are going on for months, the new company has acquired that liability. So it's always a good idea to do due diligence during the M&A activity. And now, more and more, if you want to get cyber risk insurance, whether it's to have data in the cloud or just behind your own network, they're wanting to do more and more due diligence regarding who they're insuring. Now, there used to be, this is an older slide, which I will be updating. Used to be only 2 rules, the privacy rule and the security rule. And we'll be talking about 2 new rules, the enforcement rule and the breach notification rule. So now there's 4 parts to HIPAA. These are just some of the key pieces to the HIPAA privacy rule. One that I want to point out, if you have looked at the audit protocol, and you should be using the audit protocol updated for the Omnibus Rule as a part of your controls evaluation, in it you'll find that if you're doing everything else right, but you're not properly sanctioning people for violations of, for example, your acceptable use policy, there's no teeth in the program, and they consider it a paper program. So you have to make sure that that supervisors and managers all understand that when individuals are violating your acceptable use policy and any other privacy and security policy, that those are properly reported and that it goes through the proper progressive disciplinary process in your organization. The other is audit control and trail program. So what does that mean? That means activity-based monitoring. Department of Health and Human Services came out just a few days ago, and in addition to encryption, in addition to risk assessment, said there's two main things you need to be focused on. Encrypt, encrypt, encrypt. Everything, including you should encrypt internally between servers in your own data center. And you need to be doing activity-based monitoring of your workforce members. In fact, there's a relatively new enforcement action on that. I think we'll start seeing more. Sometimes there's confusion between the terms use and disclosure. Use is really about direct control internally, and disclosure is about the transfer information, sharing it with a third party. And so really there's only 4 ways in which you can create, use, or disclose PHI, and that is obtain an authorization. We'll talk about the difference between a consent and authorization in a minute. Or a waiver from an IRB if you're doing research. De-identify data, and there's only 2 ways that you can properly de-identify data. Or create a limited data set, which requires a data sharing agreement. Minimum necessary. This is really a hard one. People go, what does it mean? Well, if you think about privacy being the privacy data lifecycle from collection to access to use to sharing and transfer and storage and disposal, if you think about it throughout that whole process, it means we're going to collect the minimum necessary. We're going to grant people the minimum necessary access for legitimate business purposes. We're going to share the minimum necessary. We're going to store the minimum necessary. There have been instances where there's been enforcement actions on you stored information that there was no longer a legitimate business reason, and that information got compromised. That was completely unnecessary. That's considered willful. And yet, it's a very challenging thing to implement. But minimum necessary is something we have to consider throughout the whole privacy data lifecycle. HIPAA security rule. Again, this has not been updated by the Omnibus Rule, so what I generally do with clients, if we're not going to make the big leap to something like ISO 27002, I added the 7 elements of the U.S. sentencing guidelines for effective compliance programs. You definitely should do that because sanctions are meted out based on that. And I also add in the SANS top 20 critical security controls. Verizon Business does by far and away the best annual data breach investigation reports. And they used to come out with recommendations. Here are the common root causes to the 97% of the breaches. And here are the recommendations for what you should be doing to remediate those. Well, they don't do that anymore because now they're participating in the development of the SANS top 20 critical security controls. I used to look to that religiously, and I don't do it anymore. I just automatically stack in the 7 elements of the U.S. sentencing guidelines and the SANS top 20 critical security controls in with HIPAA, so that where they have commonality, it just basically expands the scope a little bit. And it puts organizations into what I consider a better legally defensible position. Make sense? HIPAA security rule. This is just generally the framework. I want to point out a few things here. We're not going to go through all of them. If you don't have security incident procedures, you're not going to be able to properly fulfill your obligations now to be able to analyze based on the 4-factor analysis whether there's a low compromise risk of the PHI. So that absolutely needs to be there, and you should be doing some kind of tabletop exercises to make sure that you're ready. Anything else jump out? Yes. So as I was going through the HIPAA audit protocol the first time, I discovered that KPMG added in a ISO 27002 domain that's not in HIPAA. It's Information Systems Acquisition, Development, and Maintenance. Again, if you're not looking at the protocol, you wouldn't know that. And yet, if they audit you in one of their surprise audits, and they're going to be expanding the audit universe this year, they're going to hold you accountable for that. If you need more information about that, let us know. Okay, moving beyond HIPAA. To the extent that state law is more restrictive, it preempts HIPAA. So you also have to have an eye to state law. So not only do I train people on what are the 18 direct PHI identifiers, I also train them on the PII that states include. And California recently expanded their definition of PII. There's also a number of state health insurance privacy laws, and with one of my clients, I also have to worry about the 39 state genetic privacy laws. Luckily, Andy puts out two books a year on the data privacy laws, and I was able to easily do research and put them in a spreadsheet. And when I'm building consents, which I had to do 5 just in the last couple of months, around genetic privacy, I look to what the 39 states say because they're different than HIPAA. And there are 5 states that grant personal property rights to genetic information. Anyone here have genetic information as a part of their universe? Then I'll skip it. Okay. 46 state privacy breach notification laws. You can't just look to the HIPAA requirement of 60 days. In fact, California has a notification requirement to the California Department of Public Health for certain people in this industry of 5 days. Other states are 30 or 45. State AGs have been trained, by the way, recently. Okay, BAA, we're past the BAA development and compliance timeline, except for the fact that existing BAs, you have up to another year to negotiate a new agreement. And as I said, you've got a BA agreement on at the HIPAA at the Department of Health and Human Services website, but you can't completely rely on that. You need counsel's help to get that in good shape. BAs are now directly liable for violations of certain provisions. One of the things that I try to make sure everyone understands in organizations I work with is don't pre-select a service provider and then tell me to do due diligence on them. If they're not working in the healthcare space and they find out they're directly and criminally civilly liable and they're not in other industry sectors, they might walk on you. So it's always a good idea to train your people to serve up a number of service provider prospects so you can do proper due diligence on them and not eliminate the one that they ended up focusing on. BA definition has been expanded to include a few new organizations. One of the things that organizations had relied on was this thing called the Conduit exception. The Conduit exception was unfortunately more broadly utilized than it should have been, including some organizations were thinking that cloud providers were conduits. Conduit has been more narrowly defined to say that if the data is in transit and it's only temporarily maybe residing in an instant, then that can be a conduit, much like an ISP. But if it's being stored, like it is with a cloud service provider, clearly they're not a conduit. And now if you go to AWS, you'll see that they are HIPAA certified. BAs obviously need to make sure that their downstream contractors are now aware of their direct criminal and civil liability and are complying with all aspects of HIPAA. Fernando mentioned this morning that there were 150 audits completed. None are being worked on this year in 2013. They are digesting what changes they're going to make to the audit protocol, and so we expect that to get that maybe early next year, and the universe of who they're going to be auditing is going to be expanded to include BAs. What they intend to do, what we're hearing is they're going to reduce the length of the audit protocol. So probably what they're going to do is focus on the common findings and rotate in periodically, this is how I would do it, a sample of the other standards so that they can continue to test to see if there are other issues reoccurring. So I think you still need to use the entire audit protocol and not the slimmed down version if we can, if they actually will publish that. But obviously the common findings is where you're going to start if you're prioritizing things. So again, what do you do to ensure BA compliance? Proper due diligence. One of the things that, and Amy's going to get this in a little while, one of the things that I do is I rank data by sensitivity using some benchmarking data that Andy's done, as well as just knowledge of regulations and laws. So being a risk manager, I don't apply a black and white one-size-fits-all approach. If you think about risk being on a scale and control effectiveness being on a scale, and at the top of control effectiveness is preventative and detective controls, and at the bottom of the scale is just detective, preventative, and detective. If the risk is low, I'm happy with detective controls. If the risk is high, I want preventative and detective controls. And when management and executives understand that you're going about this in a reasoned approach, we're not just applying the most rigorous controls against the less sensitive data, they'll work with you. They understand that you have their best interests in mind, and it seems like a reasonable approach. So when you're conducting due diligence, the first thing I want to find out is what data they're going to have access to, in addition to the other things that Fernando talked about. And I make that part of my risk ranking of the BAs, okay? And so if it's the highest sensitive data, I want an independent audit. It's not just for me. The next Fortune 35 company that wants to do business with my company is going to be looking at, my client's going to be looking at the choices we made, because the service providers are also going to be some that they're going to be relying on. So you got to think beyond just yourself and think also about how you could demonstrate compliance to others that want to do business with you. So as it goes, if it's less risky, then I use a questionnaire. But I'm very reluctant to use a questionnaire when it's the most sensitive information involved. And again, that's just an example of using data sensitivity. Now, sometimes partners will impose additional requirements beyond HIPAA. I use an information security agreement to stack in with the BAA agreement. And then periodic monitoring. Well, what is periodic monitoring? Again, I use data sensitivity to determine the due diligence process I'm going to put them through. I'm not going to do a site visit if they've got less sensitive data, right? And the frequency in which I do it. I've built this matrix based on data sensitivity, and I've I feel real confident in justifying the approach to an auditor. Now, one thing, though, that gets lost sometimes is should have known. We talk about what we know, but sometimes you should have known something. For example, you need to train your folks so that if you've got a business associate that's sending you PHI in unencrypted emails, and that's just one example, that they're logging that information and alerting you, because that's a pattern of activity. And pattern of activities have to be surfaced so that you can deal with it with the BA and potentially, deal with your executive counterpart with them. Not doing that really puts you at risk. Okay, so that has to be thought about as part of monitoring. There are mandatory elements. The timely reporting to you, I have a form of what I require them to report to me. If they don't have all of the information, my BAA says you provide it to me as you get it. But you don't wait to, well, I didn't have all the information provided to you, right? There are negotiable elements, best practice elements, all have to be thought about. I talked about the pattern of activity, and I mentioned the grandfathering. Okay, Andy's going to jump in with breach notification. You need this.
I need this. Thank you. So we'll talk, my perspective on it is I obviously do the regulatory side of this, but I also have handled more than my share of enforcement matters with the Federal Trade Commission and the Office of Civil Rights. So I want to give a little kind of color on what we see out there when we're handling breaches and what we see enforced as well. The big change is this flip. We'll talk about in a moment of the burden of who has to prove either there was a breach or whether you have to prove there wasn't. Obviously, we're dealing with a rule that says if there's an acquisition, access, use, or disclosure of unsecured PHI, then we have an issue. And so there's a variety of things that happen. We have the wall of shame, as it's affectionately known, which is you have to post on HHS's website, or they do it for you. You have to report it to them. If it's a less than 500 breach, you're doing sort of an overall yearly reporting. Most of the breaches we obviously care about are very quickly over 500, and so we're concerned about what we have to tell OCR when we do this. And so the typical process is I have gotten more official process, but most of the time these things start with a call or an email or a letter saying, gee, we'd really like to know more about this. And that can go away, or it frankly can turn into a resolution agreement and a corrective action plan pretty quickly. And so I've had the pleasure, I guess, of doing it in both forms, and it's hard to predict necessarily where those things are going to go. You can see risk of harm is sort of baked into this. The quirk of state and federal law here is there are certain states that have risk of harm triggers. So if you don't have risk of harm, you don't have to disclose the breach. Other states like California have no risk of harm, and so you can have a medical information breach that may or may not be a HIPAA breach, but may be disclosable under certain state laws. California being one. There's about 5 or 10 other states that include medical information in their breach definition. And so one of the difficult questions is if you're giving notice to residents of 10 of 46 states, if you have a nationwide breach, do you give notice to everyone? Or do you say we're only going to give notice to certain people, and that raises some legal risk even if notice isn't required? And then you have the problem of you're disclosing a medical information breach that may not be a HIPAA breach or may be a HIPAA breach depending on the law. And so you have to sort of run through this matrix of saying, if we're going to disclose here, do we also have to disclose over here? And that's not always an easy analysis to engage in, particularly in the heat of the moment of a breach. Obviously, we have exceptions, and these, I'd say, generally track state law when you look at it. So I'm sure people in the room have dealt with all of the wonderful 46 state laws. Obviously, unintentional acquisition by a workforce member if an employee gets it accidentally, usually not a breach. Obviously, you have the peaking issue you see, which is not unintentional. So you have to kind of draw that line as to when this was unintentional or when it wasn't. Inadvertent disclosure. I will say we obviously have access to PHI at the same covered entity. One of the very common breaches, we'll call it, is someone sends the information to the wrong business associate or covered entity. What do you do when that happens? Is that a breach or is it not? We obviously have one here that we use a little bit, which is someone couldn't reasonably retain it. And so when you do have that stray fax, let's say, that has PHI, or that stray email, many times you'll get a declaration from that covered entity or business associate that got it saying, we looked, we didn't keep it, we didn't retain it, and that gives you the ability to at least argue that it wasn't a HIPAA breach because they didn't retain it. There's no risk of harm as a result of that, and we'll talk about those new standards, but that's a very common sort of situation I'm sure many people in this room have dealt with, which is, what do you do when that happens? The big change, which may or may not be a change, is impermissible use or disclosure is presumed. The old rule, a breach was not assumed. The new rule, it is presumed, but you have a 4-factor objective test to look at, and the commentary from HHS, at least from what they had said when the rule came out, was this was not intended to change when breaches were or were not reported. So what, to use the lawyer words here, what they've done is shift the burden of proof to you as the covered entity or business associate to justify why a breach isn't a breach, but in their view, that doesn't change the outcome. It just changes really the documentation. Whether that is how they continue to interpret it over the years, we will see, but their view was this didn't substantively change the analysis, it just shifts who has the burden of proving what. Obviously, the nature of the PHI and the extent involved, and that is both whether it's identifiable, but it's also the type of information. And so, at one side of the scale, I'll say I have clients in the insurance industry. Technically, I think the fact that you are an insured is probably PHI because it goes to sort of the payment aspect of this. It is certainly not very sensitive information. It's not the same as knowing I'm a patient at a alcohol abuse or drug abuse facility, which obviously reveals more PHI about me, merely my name coupled with that. But it does give you some room to say, if the nature of the information is not sensitive, you can, I think, get to risk of harm there, and it's easier to mitigate, losing someone's name as an insured versus losing someone's name as a patient in a alcohol rehabilitation facility. So again, we see there is this presumption. I think the risk assessment is really the key now, which is how do you look at this data apart from saying here's where it went and say we don't believe there's sufficient risk of harm here. Frankly, one of the ways we have here is I've spent a lot of time at the think tank I run, so I'm a lawyer by day, but I also have a think tank I run and I research really information. And one of the things I've done is spend a lot of time asking people what they find to be sensitive. And so what you see here is a truncated list. This is the top of the first quartile. You can see what people find sensitive is their social security number. What we now have in California's data breach law, which is password or other personal identification number to access and encounter services. That's now a data breach in California. Credit card, you don't see a lot of health information up here yet. We'll get to where it falls in a moment. But one of the ways to look at this is to say, how sensitive is this data? Because if it's not very sensitive, there's probably less to no risk of harm. We start seeing information coming in related to health in the bottom of quartile 1. We see health plan beneficiary numbers, we see lab test orders, health insurance application information. We also see information regarding health conditions. And so part of this is looking at the reality of a security breach from your security professional side saying, is this really a problem? Part of it is looking at it, frankly, from the patient's perspective and saying, how sensitive is this data? It may be PHI, but is it really considered to be that sensitive? And I think that's an analysis that can help you in many ways try to deal with this risk of harm trigger. When we look at quartile 2, and so what I've done is rank 100 common data elements by sensitivity based upon what people have responded about and said what they find to be sensitive. you can start seeing here more, you see more financial information. You also start seeing identifying information. So you see serial number for a mobile device, IP address. You start seeing location-based data, a UDID. You still see health data here. Disease information obviously is sort of the middle of quartile 2. So again, when you lose information, this type of research can help you assess that risk of harm and how you've mitigated and what you might need to do to sort of deal with it. Quartile 2, we continue to see health data sprinkled in here. Information regarding employment appears, and so I've done the top 2 quartiles on these slides. If people want more information about it, I'm happy to send you a number of the white papers I've written, and just give me a card after we're done. But you can see there are very strong patterns. What I haven't put in this deck today that I'll talk about right now is not everyone feels the same about privacy. And so when you get into, we've obviously talked a lot about security. To me, security is very binary. There's, as Michael laid out, there are very clear standards. We can debate how applicable they are at times. Privacy is not that easy. Privacy is, as a lawyer, I talk about it in terms of rights and those things, but that's not really what privacy is. And the example I use is if, whether it's someone in a restaurant having a very loud conversation about a very personal matter, it makes you feel uncomfortable. Or if you tell someone something in confidence and they repeat it, you're not very likely to trust that person again. And that's sort of that gut feel, that's privacy. And so privacy, as we talk about it, is really a societal norm. Sometimes we put it in law, sometimes we don't, that expresses concern and limitation on the collection, protection, processing, and deletion of data. We can say it any way we want, but that's what privacy does. It is it's sort of a regulator on those 4 components. And so part of this is, from a security perspective, the standards Michael's talking about are where we need to look at best practices. I would tell you from a privacy perspective, where you need to look is your patients and your customers, because this is an individual issue, and baby boomers feel a lot differently about it than people that are younger and older. They're very sensitive about privacy. They're very sensitive about their healthcare privacy in particular. People with high incomes and higher education levels care way more about their health data than anyone else. And so as you build a program, putting security aside for a moment, to me, the thing that is not looked at very often is, how are your patients going to react if I lose this data? And how can we tailor our program to meet what they think should be done, knowing that we have a patient demographic that skews to one age group or another, because there are very clear differences in the research I've done between people of different age groups, people of different age, and people of different education. And so that is the challenge of privacy. Is it's not as simple as saying, if we follow an ISO standard, we've got it under control, because the reality of privacy is it's a brand problem. People will stop coming to your hospital. They will stop using your services if they don't like what you do with their information, or there's a major breach. There are obviously other implications, but that is something that needs to be factored in when you build these programs out. Part of the way you get to all the fun of no one showing up at your hospital or using your services is when you have an enforcement matter. If you want to draw attention to your company in a very bad way, get a consent decree or resolution agreement. I've had a few. If you want to read, I don't think my name was associated with it, but there was a provider in this area that had a hospital CEO show medical records to a reporter. That got them a resolution agreement last year or earlier this year. And so there are a lot of times where things can really come out. Sometimes they have a brand impact, sometimes they don't. But the point is, these investigations can go a lot of different ways. And they begin in a couple different ways. Patient complaints are one of them, or complaints to the Federal Trade Commission. The Federal Trade Commission has gotten very aggressive in medical information privacy, and so they believe they have some form of jurisdiction. Even though there is HIPAA, they believe they have Section 5 authority, which is unfair and deceptive trade practices. So it certainly is more likely you're going to dance with OCR, but I've got one right now where we're dealing with the Federal Trade Commission with information that certainly could be covered under HIPAA, and they are being very aggressive in this space. The nonprofits in the room, you have a little better chance of avoiding the Federal Trade Commission given other jurisdictional limitations, but putting that aside, they're very focused on medical information right now. Compliance reviews, so if you are subject to one, you have one, and OCR finds out or is involved in it, obviously not going to be helpful if they find problems. Breach report, it's probably their easiest source of enforcement matters, and I will tell you, they do not limit it to the breach. I've had these that start as a breach investigation and spin off very quickly into information controls or data security apart from the breach. And so just because you start over here doesn't mean OCR is not going to dig around and try to find something else if they can. Obviously the KPMG audits are out there as well. And you can see we've got sort of a beginning of a list here of who may investigate. Obviously, Health and Human Services Office of Civil Rights, or OCR. State attorneys general have some HIPAA jurisdiction. It is limited, but they are being very aggressive. California's AG has its own power under the CMIA, California Medical Information Act, and Camilla Harris is being very aggressive as well. DOJ, I see Federal Trade Commission more. And so the reality is there's a variety of people that can come in and start probing around, and also you have the risk of class actions as well. Under the enforcement rule, obviously HHS certainly wants to enforce, but they are statutorily required to. They do have discretion in certain circumstances. They, I will say, tend to err on the side of investigation, not deferring. The interesting thing of OCR and HHS is they're more likely to impose a penalty. The Federal Trade Commission, if they come after you for a Section 5 violation, as we talked about earlier, you're more likely to get a consent decree which requires you to have process change, which I think between Michael and I, we've done 6 FTC consent decrees now. And I will tell you, if you're a Fortune 50, you're spending 8 figures a year for 20 years dealing with the FTC. Between compliance and other things you'd have to do. So it's not that there's no cost to those, but there's not a direct civil penalty. OCR has been getting civil penalties and continues to try to get those. And you also have the same kind of injunctive relief of changing your HIPAA program or changing your program around to meet their requirements. So these are not inexpensive escapades, and you want to avoid them at all cost. So we've seen obviously civil penalties up to 1.5 million with these factors. I will tell you that certainly doesn't mean that your max exposure is 1.5 million, because all they have to do is find multiple violations. And so if they hang their hat on one, you know what your max exposure is, but I will tell you when they find one, they usually find more than one. And so you can have a obviously staggering amount of penalties build up very quickly if you're not careful, and OCR doesn't feel you have the program you need to have. One of the changes is obviously there was a change with business associate enforcement. There used to be more cover for the covered entities, if you will, to say, this was the BA's fault. So there has been this risk shift, and there's more sort of direct liability or indirect liability for covered entities. The good news, I guess, is by contract now, if you're a covered entity, you have much more ability to shift liability to the business associate. And so you've got to do your diligence. It really makes the diligence piece of doing these business associate agreements much more important. But once that's done, if you can show defensively that you did do the diligence and they appeared to be in good shape, there's more ability to shift that risk onto the business associate and their downstream subcontractors. So for the business associates in the room, the problem's going to be when the covered entities have a problem. If they've done what, frankly, many of us tell them to do, they're going to point the finger right at you and say, this is their problem, we did what we could, but there's no way we could have known this, and this is their fault. How that's going to play out, we don't know yet. I have not seen or handled yet a sort of covered entity business associate type dispute where we get into that level of detail, but the covered entities certainly are aware of this and trying to push as much liability off of themselves as they can. I know we're kind of coming close on time. I want to talk about the privacy rule, but I do want to kind of give people a chance to ask questions because we've got about 10 minutes left, it looks like. So do people have questions I'd like to ask now before we go down the privacy rule, or do we want to just keep plugging away? I think we'll keep plugging away. Marketing. Rule in transition is a nice way to say it. What they've done with marketing is really segment marketing and sale of information. And so marketing involves, not surprisingly, marketing, but it doesn't involve actually selling information to a third party. The difference here was that this requires financial remuneration from a third party. So if I do a program where, for example, I create a wellness program, I'm not paid to communicate directly with patients about a third-party product, that, under the way this was drafted, was probably not marketing. I have to be basically paid to be communicating with a patient as a covered entity to trigger this rule. The, of course, challenge of this is a company, I believe in the Midwest, challenged this rule on grounds that are very familiar to those of you familiar with the INS dispute, on the East Coast on First Amendment grounds, saying this violates the company's people's First Amendment rights. There is going to be a new rule. We don't know exactly what it's going to do. I think it will be much more limited than even this was. But as much as they tried to do, I don't think it really limited companies that much if they were smart about how they could do this. But the only thing I do know is what's on this slide will not be the final rule, even though we allegedly had a final rule announced. So we'll see where the litigation goes. Obviously, you do need authorization to do this kind of marketing. I will tell you that under the CMIA, there's also very specific rules, font requirements about what you need to get from a patient to use their information, at least in the AG's view, for marketing purposes. So if you are doing marketing, putting HIPAA aside, you need to make sure you're compliant with California law, as well as a variety of other marketing laws out there that are at the state level. I don't see HHS coming in and enforcing the marketing rule anytime soon, given the fight they've already got. I mean, Michael, what are your thoughts about that? How have you seen that playing out?
I think you're right.
Sale of PHI, and this is a little different because you can see lawyers love these words like direct or indirect or remuneration. The difference here is it is not financial remuneration under this rule. It is any form, whether it's in kind or anything, at least in HHS's view, if you're selling information. So rather than doing marketing, if you're actually pushing this information off to a third party for their own use, it is a lot harder to do that now. That rule has not been challenged. There are exceptions that are listed on the slides. So the thing to do here is to think through, if you are going down this path, how do you structure your program so that you minimize the impact of these laws? And one of them is, frankly, de-identification. When I set these programs up for companies, one of the things we try to do is have two separate databases so that we have all of the, I'll use this term sort of loosely, the PHI, the medical information in one database, and we've removed, to the extent we can, the 18 PHI identifiers. So we don't know who it is, we just know this person's out there and they have a number. When we push marketing into that ecosystem, we typically do it in a way where the third party gives it to us, we push it out through our system, and if people choose to click on it or choose to use it, that's a better model than us going to a third party saying, we have 10,000 people who, based on their buying habits, think we probably think they want to buy your product. That probably triggers this rule, even if it doesn't. It's something that gets the ire up of HHS to a degree, but certainly the state AGs. So again, if you're going to do this, really think through, is there a sort of, not in the minimum necessary way we talk about under HIPAA, but is there a way to minimize the amount of information flow and de-identify this information so that there's less inherent legal risk here? These are the other sort of exceptions to the sale of PHI. Interestingly, I mean, merger and consolidation is one of the hardest issues I deal with the Federal Trade Commission. There is no such exception. If you haven't told people you're going to transfer their information, it's very hard to do it. Good news is in healthcare, we sort of have this little exception baked into HIPAA. So Not to say you shouldn't do diligence and not to say you shouldn't make sure the policies are right, but you do have a little more wiggle room, I think, with selling PHI, at least in that context, than you do under Section 5 of the Federal Trade Commission Act. Fundraising, I don't know how relevant that is for people in the room. The good news is they expanded the rule, let you do more than you used to be able to do. Obviously, there's certain forms of PHI that can be used that you couldn't use before. This rule has become much more like, I'd say, the standard marketing rules, whether it's TCPA or CAN-SPAM. You sort of have an opt-out system, so if people haven't told you you can't do it, you can do it, generally speaking. You obviously can't condition treatment on their decision to receive or not receive fundraising. But you know, again, we do have more wiggle room here, which is a good thing. So if you're engaging in those kind of activities, it does not fall under marketing or sale of information. It typically falls under this rule. Research, the big thing is, can you combine? This was, I think, one of the biggest changes, combining authorizations, doing what we call a compound authorization. Your ability to do that has been enhanced. Obviously, there are certain conditioned things you can do on research that you can't do on fundraising, and so not an issue that, frankly, most companies deal with. I just want to highlight it. You do have much more ability to condition treatment on some of these research things, and so if you're looking at research, these rules have changed in a positive way. And so, you know, if you look at this from the covered entity perspective, the big positive changes are a massive risk shift to business associates, much more freedom to do fundraising, and much more freedom to do research. The marketing rule is a mixed bag. I think the sale of information is probably not a great rule overall from the covered entity perspective, but my sense is most covered entities are not out there selling information as much as other businesses. So overall, I think the covered entities, if you look at it from their perspective, did pretty well under the revision so far. So I'm probably not going to start individual rights because it's going to take me longer than the time I have left. So I will open it up to questions again. And if we have no questions, I will try to get us out of here on time to a little early for lunch. So do we have any questions? Yes.
Hi, great presentation. What's the bottom threshold for you're seeing that organizations are being audited in the healthcare space? Is it 100 beds? Is it 1,000 beds? Are they auditing clinics? Are they auditing nursing homes? Thanks.
Yeah, all of it's sort of anecdotal, and I've worked with KPMG a lot, so I've gotten sort of what I can out of them. I think what we tended to see was smaller providers. So one of the quirks of this system was if you were a big company, well, not a big, if you were a company that had hired KPMG to do work for you, you were inherently off the list of audit because there was a conflict. So I would say both because of that and because of other reasons, I'd say the sample of audits skewed smaller company. I think the concerns that HHS has had off the record tend to be about smaller providers and business associates, and I think that audit sample probably skewed towards smaller providers, probably even more doctors, but certainly other hospitals and that. But I think they certainly did hit some of the bigger players, but I think they hit a lot of smaller players. Michael, any thoughts?
Yeah, they've actually got Booz Allen doing developing the universe from small to large. Of course, some of the large get knocked out, and the entire spectrum. So they've got 3 different consulting companies in here. KPMG does the audits, and then PricewaterhouseCoopers actually finalizes the audit protocol. So it's kind of a convoluted process.
Yeah. Any other questions? We have one right there. Okay, probably one more.
Yeah, I have a question for Michael. So you talked briefly about encrypting the data between servers. So in other words, the data over the wire or in transit. Do you ever see it getting to the point where we'll have to be looking at certain cases where we might have to encrypt the data at rest on the back end?
I think you should encrypt data everywhere. I mean, at this point, there's no reason not to. Only Massachusetts requires you to encrypt your mobile devices. But I think that, you know, again, what it's going to come down to is if it got compromised, where's your risk assessment about accepting the risk of doing that? And since you can't really justify it, the default, I think, has to be we encrypt everything. In transit, at rest, and what's the other one I'm missing? In transit, at rest, in use, thank you. So, yeah, it's time to, at this point, the next stage was people were encrypting mobile devices, but then you start seeing break-ins and people stealing desktops. So then the thought has to be, how can I justify on a, you know, a risk assessment to accept that risk? If there's going to be any risk of PHI being on it, you got to encrypt. And if you're not certain, you got to encrypt. So one way to do this, when I do strategy sessions at the end of due diligence to talk about how can we really segment and isolate where the PHI is located so that maybe we reduce the burden on others. And so what happens is you end up with policies and procedures and acceptable use for non-network, because you can still compromise the network, right, even if you don't have access to PHI, and then tighter controls around where the PHI is located.
And one thing I'll say too is I think putting aside, you know, desktop or mobile, the reality is encrypting gets you out of virtually every security breach law out there. And so whether it's the standard or the best practice, it can save you, you know, millions of dollars on a breach if you avoid one breach a year by encrypting. So I think, you know, however you get there, I think that's probably one of the easier sells to your management is to say, you know, if we have a breach, it's a couple $1 million if it's a big enough breach and there's a huge brand hit, or we can spend X on encryption. Which would you like to do?
You know, at the end of the day, I think sometimes we get to looking at what does the standard or the regulation say? And I think black and white compliance is not a legally defensible position. I train people to who are the risk owners. They may not know they are the risk owners, so the first thing is identify who the risk owners are in the organization, and you train them to do two things. Learn how to foresee the risk and apply a reasonable standard of care. So that's the kind of activity that you have to do over and above HIPAA compliance. And so then you get to, should we encrypt, or, you know, what else should we be doing?
All right, thank you.
Thank you. I think we have an announcement on lunch. Oh, one more? Okay, yes, sorry.
Yeah, with regards to, you mentioned about when you try to gather independent audits, you know, I saw SSA 16 SOC 2, type 2 type audit. What other forms of independent audits do you find acceptable?
Well, obviously, if they've engaged one of the major independent auditors and they've audited them for HIPAA or ISO or whatever my requirement may be. Again, sometimes my client may have partner obligations imposed on them to be more than HIPAA compliant. So it's kind of there's not a one-size-fits-all. I look at data sensitivity, that's always in my mind, but also, you know, are there any partner contractual obligations that we need to think about as well? So I build a custom matrix for each organization based on all those factors.
One of the things that I have heard, everybody keeps talking about encryption. Everybody keeps talking about encryption. One of the things that I know is a major risk for using encryption is keeping of those keys. So those keys need to be backed up somewhere in escrow, somewhere away from the data. And very few people are addressing it.
Yeah, the keys need to be stored off the server or off the location, or they should not be in the cloud. If you're encrypting your data in the cloud, they shouldn't be in the cloud. Yeah, that's a good point.